My name is Tim Barton. I'm an attorney in Doylestown, and we're here for an Act 53 CLE. I'd like to introduce everyone. To my left is Diane Rosati. She's the Executive Director of the Bucks County Drug and Alcohol Commission, and who has, in large part, spearheaded the renewal of the interest in Act 53. Also, President is Renee Calhoun, who is with the Bucks County Commission. She's the Approval of Care Clinical Supervisor. So Renee is someone that you would want to contact in the event that you were pursuing an Act 53 matter. I'm sure almost all of you know Rob Mancini, also local attorney. Before we begin, I've been asked to let everyone know that this is Robert Whitley's up front. He is videotaping this, I guess for posterity, and also to thank our sponsor, the Bucks County Association of Township Officials. We really appreciate their assistance in getting this up off the ground. Judge Boylan is not going to be coming today, but I will suggest to you that Judge Boylan and Judge Finley are the two judges in front of whom most of the Act 53 petitions are litigated, and Judge Boylan has a very keen interest in Act 53 and helping juveniles that are targeted for this program. We're going to start, Diane is going to begin the program by talking about what Act 53 is and what the Commission's role in Act 53 is. Can give a good overview of how it works and what it's intended to do. I think ultimately Rob and I will talk to you about more of what happens when an Act 53 petition actually gets to court and it gets in front of the judge, and maybe some of the problems and kinks we're still trying to work out as we move through the judicial process. Diane?
Thank you, Tim.
Sure.
Good morning, everyone. Good morning, everyone. All right. Thank you, and thank you to Stacy, who's the Executive Director of the Bucks County Bar Association, for helping to organize this event. We really appreciate your time here. We've kind of scanned the audience and know that we have a pretty diverse group, so we'll try and meet the needs of everybody. You're not going to learn all there is to know about Act 53 or assisting folks to access services, especially minors, in this 1 hour. But Renee and I want to make ourselves available either after today's presentation or any other time. We're certainly available to you. I want to start with a little bit of sort of general information. It's important for everybody to start with some basic information about who's the Bucks County Drug and Alcohol Commission, just news you can use. What's our role with Act 53? What is Act 53 and what's the process? So I can share some of that basic information with you, and then I'll yield my time to Renee, who will talk a little bit more in depth about our experience with Act 53 since we've relaunched it almost a year ago, and she has some interesting information and data to share with you on what we see so far. I want to thank also our board of directors who have really encouraged revamping of Act 53 up to and including funding legal representation of the minors. So you see here before you the two attorneys who are representing the minors in these cases. So I want to thank our board for making sure that we ensure that the minors are represented in these cases. So Bucks County Drug and Alcohol Commission is the SCA, or the Single County Authority, the lead drug and alcohol agency in Bucks County. There is one of us in every county. If you're working with other counties, there is an office like ours assigned to each county. We oversee and fund and monitor prevention, intervention, treatment, and recovery supports for Bucks County residents. So if you have any questions at all about services in Bucks County, you know someone who has a substance use issue, you have a friend or a family member who is encountering some sort of barrier accessing services, they don't have funding to get treatment, any and all of the above, and 100 more areas, please feel free to call our office. So our number is 215-773-9313. You can call anytime during the day. I've been at lots of meetings recently where community members have said, what about a hotline? What about what New Jersey is doing? Governor Christie is doing an incredible job of getting the word out. Well, you may have seen in the last couple of weeks, and even on my way here, I had KYW on. Governor Wolf has launched a campaign in Pennsylvania to make sure that folks know that there's also an 800 number for individuals 24/7 to access services. So I want to make sure that I give you that number. It's 1-800 662-HELP, H-E-L-P. So that is the statewide phone number we want to make sure that you have. So among our roles and responsibilities at the Drug and Alcohol Commission are to ensure that individuals have access to services and to be responsive to community need. And Act 53 helps us to do just that. Act 53 in Pennsylvania was enacted in 1997. This is not a new law, but it is one we're paying much closer attention to. And SCAs, single county authorities throughout the state, have begun to get on board with what Act 53 really does and means. We've had a process in place for this involuntary commitment of minors for substance use for many years. But just in the last year, we've revamped our process in Bucks County. How did we do that? We got together a group of concerned county-related leadership individuals, including certainly Judge Boylan, the district attorney, public defender, community providers, and our agency and local attorneys to develop what we thought would be the most expedient, most customer-friendly process where we can help parents or legal guardians who just are at their wits' end. They just don't know what to do. So years ago, parents would call our office and say, I know my child is using, they refuse treatment, what can we do? And we might be able to provide support to them, point them in a direction, but we would ultimately have to say, until they're ready for help, there's really nothing we can do. Given the current opiate epidemic and overdose, earlier first use, heroin, prescription medications, all of those issues, we decided that we would be much more proactive. And so what we decided to do was to develop a streamlined process. So how long does it take? It takes less than a week for this process to occur. And I'm going to give you sort of the thumbnail sketch of how this occurs, and then turn it over to Renee, who can give you some real-life information. You can share information, and we have flyers for you. We have other information that will give you resources in Bucks County. But please ask family members to call our office, and they will speak with Renee or with Cindy in our approval of care department. The parent just simply has to say they're looking for information about Act 53 or involuntary commitment of minors, or explain their situation. Our knee-jerk response, the first thing that we want to do is not to enact this process. We don't want to do this as the first option. So we will offer other suggestions and other options, and there are many. Of course, interventions, treatment, student assistance programs. Every secondary school in Bucks County has a student assistance program to identify and assess at-risk students. So there are many things that family members can do beforehand. Once they've exhausted all options, our staff will explain to the family member how they can file a petition for an involuntary commitment, for a hearing. And so the process is that there is a petition that's available online. It's on the county website. Our staff will explain how the parent or guardian will complete it. We've been advised by the judges who are so committed to this process. They want to ensure that parents know that they have to document 30 days minimum of knowledge of that child's use. It can't just be, I know they Googled marijuana. Or it can't just be they overheard them talking with friends. There has to be some information specifically in the last 30 days in order to move this forward. So the parent files the petition by going to the Bucks County Justice Center. They file a petition along with a fee, which is about $82, some of which can be waived. They provide a picture of their child, location where they might be found, information on what their concerns are, and the sheriffs serve the child and notify them to appear in court. And those court days are either Tuesdays or Fridays. So the child is to appear in court, and the child is assigned legal representation either by Tim or by Rob. Our office's role is simply to assist the parent in understanding how to file the application, to provide support to the parent, And we also ensure that there's an assessment that's provided. So the minor comes to court, they meet with the judge on a Tuesday or Friday. The parents are present as well. The parents may choose to have legal representation. The judge can order the assessment, drug and alcohol assessment, special questions that are asked for minors according to special criteria, American Society of Addiction Medicine, ASAM criteria. And there are many questions that are asked in discussion, private meeting with the child at the courthouse in a private room. Following that assessment, which could take about an hour, there's a second hearing where the judge can mandate treatment for the adolescent. And the adolescent is, by the way, between ages 12 up to 18. The mandate for treatment can be anything in the continuum from outpatient treatment to intensive outpatient treatment to partial level of care to residential to detox. It can be anything. And so generally that court order is for 45 days. And then the provider who is conducting the assessment on site will arrange for placement of that individual. We will pay for the assessment of the minor, and Renee can talk a little bit further about funding of treatment, but treatment funding should not be a barrier for these individuals. If you're working with families and funding is a barrier, please let us know. We want to make sure that we highly prioritize these youth and make sure that they get the treatment that they need. So that's sort of the big picture of how our office operates with Act 53. The materials that we have shared with you today are inclusive of what we call our overdose prevention toolkit, and within the toolkit are materials that we hope that you will distribute within your offices, put in your waiting rooms. We have every one of these items available electronically, and we encourage you to put them on your websites. I know many municipalities and police departments and county offices have already done that, so we thank you for that. We encourage you to do that. We really want to spread the word. Among those items are items that we have additional copies of, and that is an Act 53 flyer that you can put any place in the community that helps individuals to understand how they can access Act 53 for family members. I'd like now to turn my time over to Renee, who can give you a bigger picture of the kinds of calls that we've taken, the volume, the substances that some of these youth are using, and what the disposition has been. I do want to thank Rob and Tim, though, and certainly Judges Boylan and Finley for working so diligently with us on this. As Tim mentioned in his opening remarks, like any new process, it has stops and starts, and we certainly want to hear from folks any recommendations on improving the process further. We know we haven't perfected it just yet, but we want to make sure that we work with individuals in the community to provide the best services possible. We don't forget for a minute that our agency is managing government funds. We're managing the taxpayer dollar. We remember that every day, so we want to make sure that if there are improvements that we can make, we hear from them. So if any of you have any questions or comments about how we can improve the process, we're happy to hear about those too. So let me turn it over to Renee.
Thank you, guys. As Diane said, our office does work twofold. Specifically for Act 53, it is our responsibility to coordinate the assessment and make that occur. Secondary, our office, the Approval of Care Office, which is what I supervise, provides funding for folks that don't have insurance or don't have funding for treatment. So there are times where we're dually involved in cases because we are operating as the funder as well as providing the assistance for the families to get started with the Act 53 process. In the fiscal year 2016 to 17, so July 1 of last year until June 30th, we had a total of 35 phone calls in reference to Act 53. This is pretty important because Pittsburgh right now is very functional in their Act 53 process and has been for quite some time. And total, they've had 15 cases in a heavy year. So we actually had 12 of those cases file petitions through the court. So we're already mirroring Pittsburgh, which has been, like I said, has done this process very similarly for quite some time. Out of the 12 parents that filed petitions, 2 wound up withdrawing their petitions because their children were committed to mental health treatment, and they went down the mental health route rather than Act 53. The 10 cases that did go through the Act 53 process, 2 of those cases have been referred to residential treatment, including detox, rehab, and also halfway house. There is some issues when an adolescent goes to a detox, as you can imagine, because that is an adult facility, and so it requires much more staffing because the child needs to be in a one-on-one room, have one-on-one staff, etc. So it's a lot of coordination. We talked about the different levels of care, and so the 8 other children have all been referred to ambulatory treatment, so outpatient, partial, IOP. One of the adolescents has been in rehab twice during that time. The adolescents that have come through this process have mainly been through Middle Bucks area. They've been in Central Bucks School District, they've been at the George School, LaSalle College High School, and online schools. Most of these children are truant and have other systemic involvement, whether that be children and youth or juvenile probation, past mental health experience, past drug and alcohol treatment, or a variety of run-ins with legal law enforcement and either have not been charged or who have been through the youth aid panel process, that kind of thing. So these kids are not brand new to the system. They just may be brand new to the formal legal system. Most, if not all, of the parents have been either single parents or separated, divorced families, and most of the children, at least half, have someone else in their life that's in recovery or in active addiction, which I found very interesting. A lot of parents have been in recovery from alcohol addiction, and also siblings. So the parents of the substances that the parents are typically calling about are alcohol and marijuana, and this is typically because they can smell those substances on the children. However, these are not the substances that the children are actually using. We've had kids using K2, methamphetamine, heroin, opiate pills, Adderall, cocaine, and as far as the other synthetics, such as like kratom, that kind of thing, not all of our drug tests test for those, and the children are they're not saying that they're using them, but that is certainly a possibility. Mushrooms and acid also. The drug and alcohol providers that have been involved in these cases, Aldi Counseling Center and Penn Foundation are Gordon's here and Karen's here, are our primary assessors that will conduct the assessment at the courthouse. We've also been able to connect adolescents and their families to Pyramid, Gateway, which is out in Pittsburgh, Rehab After School, which is in Jamison and Lansdale. We've also been able to connect families to local resources such as Al-Anon, Nar-Anon, the Because I Love You support group, which is in Doylestown, and then educational groups at our providers, Family Strengthening, and then Family Group Decision Making, which are both funded by Children and Youth Office. If anyone has any questions about drug and alcohol assessment piece or treatment piece, certainly you can see Diane or myself.
Renee just mentioned 2 folks that are here that really deserve some acknowledgement. Karen McKenna, who is seated at the 4th table, is from Aldi Counseling Center, and Gordon Hornig is in the back in the dark shirt. These are 2 of the individuals, maybe I think the only 2 individuals that have performed the initial assessments upon presentation of the Act 53 petition. So they are the point persons from the judicial standpoint, and they've been doing a great job. And I'm sure they would be more than happy to stick around afterwards if anyone has any questions what the initial assessment involves or entails. Unfortunately, I'm going to give you a little bit of the dry attorney speak about how this all works and maybe some of the concerns that Rob and I are seeing, and he may echo some of those concerns, and I'm sure he'll add to it. This is, I look around the room, I do see a few attorneys and Judge McGuffin, but I see police chiefs, police officers, other members of the community that I'm sure are interested in how this works and maybe might ultimately end up speaking to parents and advising them on what benefit this can be to them and trying to help out their kids, and that's what this is really all about. Diane mentioned this is an act that's been on the books for a while. We're getting it out to the public again in this past year. There are, in the materials that Rob and I have provided, there are 2 screenshots from different internet sites that talk about what Act 53 is, that it is, the act specifically states it is for the treatment, the involuntary commitment for treatment of individuals 12 to 18 years old, Bucks County residents, and gives a little bit of the history of the act. And then there is, I put the act itself because you're not going to, if anyone wants to look this up, you're not going to find it by Act 53. It was the 53rd Act in 1997. It's codified elsewhere in the statute. So it's only 1 page long. It's, I don't want to say self-explanatory, no statute is, but you can see what the guidelines are and what the requirements are for a judge to order the involuntary commitment. And that's something I wanted to speak to a little bit. When you're speaking to parents, please be mindful that once they file an Act 53, the Act 53 petition, and as Diane mentioned, it's online, the clerk of courts have a copy of it. I think all 4 of the folks up here were involved in preparing it. We modeled it after another counties that was up and running, but we tailored it a little bit to what we thought made sense for our purposes. What happens is the parents or guardian come into the clerk of court's office, they fill out this petition, sometimes with the help of Bucks County Drug and Alcohol Commission, sometimes on their own. They read this, or they speak to one of the folks out here in the audience and say, this may be what you need to do. What Rob and I think have seen are parents who are at the end of the road. They've tried other things. They know their child is using. They're concerned, obviously, it almost goes without saying, they're concerned for their child welfare and their health. And they think this may be what I need to do for my child. But what they don't understand is once they fill out this petition, it starts a court proceeding. And I think Renee mentioned so far there have been 12 cases litigated. I think Rob has had 6, I've had 6. What happens is either Judge Finley or Judge Boylan get this petition and there's a proposed order on top. And I know you folks may not have to go through the petition, but you may be speaking to someone who will go through the preparation of the petition and the process. The proposed order schedules the initial hearing, and that's where the assessment would be done. It appoints either Rob or I to represent the minor because they do have some due process rights because this is an involuntary commitment. They're not agreeing to it. And it designates who will be doing the assessment, either Aldi Counseling Center or Penn Foundation. The hearing date, once the judge reviews the petition, determines that there's a sufficient amount of information in order to schedule a hearing, they schedule that hearing and give it back to the parents or the clerk of courts, and then is then taken down to the sheriff's department. The sheriffs go out and serve the minor. They don't arrest the minor. We want to be very clear so the parents know their child is not going to be picked up and put in handcuffs and brought to the courthouse that day. There are some other counties that are doing that, and there are reasons why those counties believe that is appropriate, but that is not how we are proceeding. The minor is served, and sometimes there's problems with service because some of these young individuals who are maybe in the throes of addiction or using or have a substance abuse problem, they're not at home, they're not at school, which is why the parents are asked to provide a photograph and contact phone numbers and various locations where the child may be found. But once the child is served, they then they're compelled to appear at court usually later that week. As Diane mentioned, this process from the commencement of the action by filing the petition to getting them into court, we would like to see done within 1 week because it is an emergency situation in most respects. If the child doesn't appear, a warrant can be issued and then the sheriffs can go out and arrest. But if the child does appear, they meet with Rob or I. We're assigned. We may have contact with them before the hearing, most often not. But we meet them, we explain to them who we are and what our role is. And there is some issue of whether there's an initial hearing for the judge. And so far, I think it's only been Judge Boylan and Judge Finley because these are being done at the same time on the same dates as juvenile court. Whether there's an initial hearing, whether to order the assessment or whether the act permits the judge to order the assessment without a hearing. So far, the assessments have occurred it hasn't been very problematic. I think the most sound advice is that the kids should go through the assessment. And so they have the assessment. Karen and Gordon can speak to the assessment. We are not, the attorneys aren't part of the assessment. I think the assessors have looked at some medical records, some previous treatment records because some of these folks have been in treatment, are coming to the court with real recent substance abuse treatment. Very often, Karen and Gordon will speak to the parents to try to get a better overview of what's going on. Certainly, they have the petition which alleges some factual predicate is available to them. But this is where real important to Rob and I think the courts maybe not as maybe wouldn't strike everyone else here as important, but it really is. What happens next is once the assessment is done, there's a part of the assessment, or at the conclusion of the assessment, there's a treatment recommendation, and it could be no treatment is necessary. I don't think we've had that yet, but the assessor could say, as both Diane and Renee mentioned, can be anywhere along the spectrum from outpatient to inpatient, and a judge has under the Act can order inpatient treatment for up to 45 days, after which a review hearing would be scheduled to determine whether further treatment would be beneficial, is the language in the statute. But after Karen and Gordon do the assessment, they come to us and they say, this is the results of the assessment, this is our recommendation. And then we talk to the child about that. We not only are we there to advocate for them, but we're there to advise them. The child undoubtedly has a right to a hearing at that point. Some of the children have, some of the individuals, these young individuals have agreed to the treatment recommendation, and we go in and we put that on record. There have been instances, a number of them, where the children have not agreed with that they're not willing to go to treatment. Obviously, they're there for an involuntary commitment. You would think the parents probably have tried to talk to the kids, their children, about the merits of going in voluntarily, and they've said no. So the children may be reluctant to agree to the recommendation, and they have a right to a hearing. A problem Rob and I have found, and I think Rob wants to speak to this a little more, so I'll just touch on it, is at that point, the parents are the petitioners in a civil action. This is not criminal. But they are the petitioners, and they have a right to counsel. So far, none have had counsel, but I have had the occasion to go into court, and the presiding judge has said, okay, we're here for a hearing. We really have to turn to the parents and say, okay, it's your petition, you have to present your case, and the parents aren't prepared for that. They think that simply by filing the petition and submitting it with the court, that the court will order order some type of treatment. That's not exactly how this works. And so any of you folks who may be talking to parents, or the police officers who will you post this in your lobby, and parents may call you, saying, what can I do? I think it would be good for the parents to know that they do have some, I don't say burden of proof, that they do, but that they are bringing forward an action in court, and it might either be wise to retain counsel, or at least be familiar with the drier parts of this packet, and that is the statute, and I've included a case regarding the due process rights of the children, which kind of indicate this is what the parents are facing, and the decision or the analysis the court has to undertake. But what happens is, the way the hearing works is, the petitioner, that is the parents, would present their case. They would testify as to their observations of drug use, why they believe there's a substance abuse problem, what acts or occurrences they have seen, preferably in the last 30 days, which brought them to court, which led them to the filing of this petition. They would also probably testify as to prior drug use, prior drug treatment history. And then the assessor is in the courtroom. Karen and Gordon, I look at them, and this is my terminology, it's not in the Act, and none of the judges of our bench have referred to Karen or Gordon as this, but I consider them a court-ordered expert witness. They then testify as to the assessment, what assessment they performed, the conclusions they drew from that assessment, and their treatment recommendation. And Karen and Gordon and I and Rob have had this discussion. They're subject to cross-examination by the child's counsel, Rob and I, because we can make an argument that that there hasn't been sufficient evidence to permit the court to order involuntary commitment. So I realize we're not here for a law school class, but the folks talking to parents should be mindful of that, because that's where, and I mentioned in my opening remarks, we've run into some problems. There are some bumps in the road that we need to work out. I think it's the parents, they're digesting relatively new information, but we need to get that word out to them it's not just the filing of the petition. There is a court proceeding that follows the filing of the petition, and that can be it can be a little bit problematic. So far, I think for the most part, this has been working out. The courts have ordered some treatment for various individuals. I think I know I have one that's in the residential facility, and we have had review hearings. We have another review hearing scheduled, and it can be a benefit. This act can provide the benefit that it was intended to provide, and that is to try to turn the life around for a kid, young, I don't want to say boy or girl, man or woman, 12 to 18 years old, who just doesn't have the ability to do it for themselves, and the parents want to provide that support network and are asking the court to enlarge that support network. And that's what we've seen so far. We think it's progressing in the right direction. But I would welcome anyone here who has questions about the judicial process, the court proceedings after the filing act, after the parents come to the conclusion, I need to get my kid help. I've reached out to the police chiefs or the DA's office or my high school or to the Bucks County Drug and Alcohol Commission, and this is the route I'm going. If you have any questions about what happens after that, please give Rob or I a call. We'll be more than happy to talk to you about it. There have been occasions where the court has actually asked an attorney who happens to be there for juvenile court to actually speak to the parents to try to advise them because they are unrepresented and they're not sure what that part of the process entails. And that has been helpful. But anyone who has any questions about that and would like to give the parents that other part of the picture, please call Rob Ryan and we'll let you know. Rob?
Good morning, everyone. I had planned on talking a lot about the legal aspect of it, and especially like the ethical concerns that I have as representing the child and what's come up with the adults. Because what happens is the parents, they are asking us for advice, or at least they're asking me, and they're looking to the court for direction. Now, I technically don't represent them. In fact, I'm potentially adversary to what their interests are. So it takes a lot of finesse. And I'm not trying to impress you, but you have to develop a rapport with the person who may be high in about 10 minutes and convince that person that you're on their side. There have been, I want to go back and just talk again about how this happens procedurally, because even though it was explained by Diane, there were a lot of moving parts to this, a lot. And those of you that are attorneys, you can imagine to get someone in front of a judge in 2 days and then potentially have them assessed and committed in 1 day took a whole lot of work. And that work was done primarily by Diane, Judge Boylan, and Matt Weintraub in particular. Really, I think he was the spearhead. And the DA's office has no involvement in this. I think he just did this because he felt like it was something that was noble, but their office is completely removed from this. And in fact, the hearings happen on Tuesdays and Fridays when juvenile court is already in session. When they have these hearings, the DA, they leave the room, they leave the courtroom, and we were pretty clear on that because we didn't think it was something that the district attorney should be having access to. So when we got together with this group, we had to put it all together, and my contribution was minimal. I think I brought water ice. That was about all. That was all that I gave to the group. But
Critical.
we knew that this had to happen quickly. So all of these people come together, and now for the police officers and you providers, I think what you can say to a parent is, listen, if you go up there and fill out this form on a Friday or a Monday, you're going to be in court in front of a judge in 2 or 3 days, most likely, assuming that the child gets served. So when you see these parents, and again, I'm looking at the police officer, you can assure them that this is for real. This isn't something that, well, they'll schedule a hearing date and we'll get notice. This happens rapid fire. And I know Diane earlier said, well, after the assessment, then there's a hearing. That hearing's that day. So the child and the parents are in court at 8:15, and usually people have been pretty prompt. And the child is sitting there, the parents say, hey, what do I do? We generally just give them some basic information. Every one of the kids that I've represented has agreed to be assessed. And I'm not in that assessment, but I will say that sometimes the child will say, you know what, I just think I need this, or I don't want to do this. And I know Gordon in particular, who's sitting back there, I mean, he's just been he's just been a real gentleman about maybe tweaking how they approach the treatment to kind of get the kid invested to it. Now, he's not going to say for someone who's falling asleep on heroin, okay, go home and you can do outpatient. But within reason, it seems he's in particular has worked with me and said, let's do this for the kid. And again, when you get the kid invested in it, it's more likely to be successful. After the hearing happens, the devil then is in the details because it's the follow-up. And you lawyers can imagine when you're dealing with a pro se person, which the parents are, they're not familiar with the rules and how things happen. What the judges do in court is say, okay, if your client has agreed to go into treatment, the assessment is done, here's the recommended level of treatment, and then they begin that, they continue the hearing that day, and they get a day. And if the child is not compliant, then we come back to court, and the judge can then involuntarily commit the child. So that's what I say to my client. I say, look, you're going to have to follow through with this, or we're just going to be back here. It's not going to go away. And I think every one of my cases might be done that I've done, and everyone, it's been quiet, except for one or two that are still out there. And again, I get the parents like calling me all the time, Johnny doesn't want to stay in treatment. And it puts me in a weird spot because I really don't want to talk to you about what Johnny wants to do. That's not what I represent him, and I'm not talking to him. We come back though, and if they're not fulfilling their end of what they promised to do, you're back to square one, and the judge can involuntarily commit them again. But I think it's been successful for the most part. I get the impression that everyone, at least that I've represented, has agreed to the assessment, agreed to treatment. What the compliance level is, I'm not positive because I don't stay with the kids too far after it's over. The other just technical procedural thing that kind of gets us screwed up is when the cases get continued and we have to go back to court, if the child is compliant, it's incumbent on the parent to notify the court that they wish to postpone the hearing. And again, I'll give Judge Boylan in particular, her secretary Kyle, credit here. What they've done is they've really made it streamlined. They allow the parent to email her. So all the parent has to do is send an email to Kyle, who is Judge Boylan's secretary, and say, Johnny's in treatment, everything's fine, I'd like to cancel the upcoming hearing. And then typically the only people that don't get that notice are us three, and we're all standing there wondering when the Act 53 hearing is, and we're wasting our time. It's really not a waste of time. These hearings are specifically scheduled for Tuesdays and Fridays because that's the juvenile court date. And Judge Boylan and Judge Finley are already there. And juvenile court starts at 8:30. So it just made a lot of sense. And I do court-appointed juvenile work, so I think I was Judge Boylan's just a natural selection because I'm there anyway, so I can do these hearings. Once or twice, we've had differences of opinion of the parents, and I noticed the statistics earlier that mostly these are single-parent families, and I think that kind of tracks juvenile court too. But I had a situation where you have two parents and they disagree, and dad's saying no, marijuana's a gateway drug. I'm not just going to ignore this, and mom is saying Johnny's doing okay in school, and you have to navigate that. And then when there's like, son of course doesn't like dad because he doesn't want to hear that, and there's custody things, occasionally it just gets a little bit hairy. So I would, naturally, again, for the police officers, refer anyone to it that you think needs it. And I think you can say to them, look, it's not really difficult. The form that you'll see up in the clerk of courts is 10 questions, and you just write a little paragraph about what he or she has been doing, bring a photograph, and file it, and that's it. Like, you don't have to be an attorney to do it. And I think if you say that to people, it'll demystify it, and I think that maybe more people will get involved. When we first did it, I expected to see all opiate cases, but we haven't. I mean, it's just two, and I had one of them, and the kid was in bad shape. But mostly it's been marijuana. And we've had some cases where, especially Judge Boylan was able to identify the other issue going on. And, one of the people, she was just self-medicating because she had significant mental health problems that weren't being treated. And again, I mean, the judges, they have that tool of saying, you know what, I'm going to postpone this, and let's see if you can get it together, so to speak. And I think in that one particular case, they got some mental health help, which made the need for the Act 53 hearing, it was kind of moot. I think that was all that I wanted to mention. One more thing. The final thing is that, and I don't think I have to say this to law enforcement, but like the final last straw, so to speak, let's say for parents that are dealing with this is, I mean, what you can always say to parents is, you know what, I mean, if this doesn't work, or if this isn't enough of a stick, and your child is in possession of drugs, call the cops. I mean, you know, that's a difficult position to put a parent in, and I've never said to any parent, if you find drugs in the house and this isn't working, call the cops, because juvenile probation is a much heavier, I don't know, penalty, so to speak, or there's just closer control through juvenile probation than there is through this, because this, for the most part, is kind of voluntary. But once a child is on juvenile probation, you have a PO and that's it. They find you high, they bring you in and lock you up. You know, just being high is not a crime. The cops can't arrest you for being high. But they can arrest you if you have drugs in your house and you have a parent that's really, someone used the phrase, at the end of their rope. I think that's the end of the rope. I think when a parent finds drugs in the house and, you know, against their better instincts, sometimes it's in the child's best interest to have police involved and to get the child on juvenile probation, because it's just much more, it's much stricter. I guess the last thing I wanted to say, now that I used the phrase in the child's best interest, and again, this is for the lawyers, that standard, you may recall that standard, that was the old standard in juvenile court, in the best interest of the child, and that still might be the children and youth like standard. That's no longer the standard that Tim and I have. We have to represent the interest of the child. So it doesn't matter, I can't say objectively you should be in treatment because you have a serious opiate problem. I can't say that. I have to say, what would you like me to do? And if he or she wants me to fight tooth and nail to keep them out of treatment and to keep the judicial system off their back and the parents off their back, I have an ethical responsibility to advocate for that. I can no longer say, you know, look at the parent winking and nod, don't worry, I'll get him in treatment. I can't do that. And I think we've just navigated this pretty well. I don't think it's been a real issue. I've seen Tim get screamed at by some kid, but for the most part, I think we've been able to, you know, our bedside manner is that we're able to just kind of say to the boy or girl, listen, this is what it's all about. This is what the options are. It just makes sense to comply. If you feel that you don't have a drug and alcohol problem, the proof will be in the assessment. What's the downside? You're here. You can sit with him for an hour and talk to him. And of course, you know, they're all in denial. And then you can say, look, I mean, this is what the guy's saying. He's a professional, and this is what the judge is going to order. And then you just kind of take it from there. And anyway, are there any questions?
What if the child does not agree to be assessed?
I think the judge can order it. I think Tim disagrees with me.
No, Rob and I have talked about this. So far, based on, I think, our conversations, and when I say Rob and I, you know, we're the two attorneys that the court appoints in the initial order to represent the minors. We don't represent them jointly. Rob is getting half of them, I'm getting half of them, but then we do talk about this. I think there was some question, statute interpretation question of what this statute requires, what it allows, and what happens in that event. I think not just for the most part. I think in every case that the child has agreed, and that's in large part on, I'll just speak myself. My advice to the child about what the statute allows. I believe, and I don't think this has been litigated, and I researched it at the request of one of the judges. I believe the statute requires an assessment. In other words, once the initial order is signed, that surface order of the petition that sets a hearing date identifies Rob Rye, appoints Rob Rye as counsel for the minor, and identifies which agency will be performing the assessment. The statutory language says an assessment shall be performed, shall be conducted. So I believe the court, if it comes to it, my thought is that the court can say if you don't go through the assessment, I can move on. I can then, I have resources available to me. And jumping ahead, so far it has, all the assessments have occurred. I'm advising my clients that they are required to have an assessment. I think if they don't have an assessment, the court would in all likelihood go forward and say that the refusal to be assessed, I can draw an inference from that, and then move on to the hearing and to determine whether treatment is necessary. I'd like to point, I hope that answers your question, but this kind of just follows up on what I was saying earlier. But then the next part of it is the child is entitled to a hearing, and it's not a best interest standard. The statute is very clear. It says the court shall hear the testimony of the persons performing the assessment, and based on that assessment, if they determine by clear and convincing evidence that A, the minor is drug dependent, and B, that he or she is incapable or unwilling to accept treatment, and that C, that they would benefit from treatment, then they have the option of ordering up to 45 days of inpatient care or some lesser restrictive treatment alternative. So the court has to actually make that determination after an evidentiary hearing. And as Rob mentioned, it all happens in one day, but the assessments have all gone, the assessments, we get there, we meet the kid. I've had one or two call me in advance because my contact information is on when the sheriff served them with the order, they can call me. I don't normally have the opportunity to get in touch with them because I can't find them, but I have had one or two call me. We talk to them, we explain to them the situation, the procedure, and they have all agreed. I believe if they don't agree, I think the judge will order the assessment.
I had just one more thing to add to that, just jog my memory on something, and this is for the police officers too. If you talk to a parent about filing this petition, one of the concerns might be whether this is somehow going to harm them going forward. Because when we did this, I thought, if the DA knows about this, and let's say that an Act 53 petition is filed and he doesn't comply or she doesn't comply, and they walk away from treatment, and then the person gets charged. My thought was the DA is going to say, well, we're not going to give him any diversionary programs because he's already proven that he's not invested in treatment. So why would we cut him a break? We're just wasting our time. But the DA, but it's not just the DA, but no one has access to this. So it's absolutely sealed. So when you talk to a parent and say, hey, if you file this motion, this is what's going to happen procedurally. And if the parent says, well, is then my son going to have like a record, or is this going to be out there, so to speak? And when we developed this, I was convinced from the clerk of courts that the record of this is absolutely sealed. There's one or two people in the clerk of court's office, and of course the parent who's filing the petition, who will see these documents. No one else could go into the clerk of courts and say, I would like to see this file and see what this allegation was that this person was doing. So you can assure them that it's a closed proceeding, it's not done in open court, and the file is completely sealed.
That's a good point. I mentioned earlier this is civil, so it's not criminal, and there are some DAs in the room, so it doesn't get a CP number. And the civil, there are different designations, like a landlord-tenant action might be LT, and a civil action may be CV. The clerk of courts have created a separate database for these petitions, for the filing of these petitions, the docketing of these petitions. It's under an IC number. I assume that stands for involuntary commitment, and no one has access to them. And they are not a matter of public record. They're not on the AOPC, so you can't do a public database search. What happens, though, very often is, the police officers in the room, and some that I know Matt Weintraub has spoke to the police chiefs about this to try to get the word out. There's often some concurrent conduct, some other conduct, such as fighting with the parents, I've seen, punching holes in the wall, possession, having, some things in their room or in the house. What I've seen some police officers do, and I from my side of the table, I would suggest very appropriately so, say, listen, if you want to, we can bring charges. Your child ends up in juvenile court, it can be a matter, that may be, those records may be more accessible, from a public viewpoint. And there is that hammer, Rob mentioned, there is that hammer of you have a juvenile probation officer, you can be placed on indefinite probation. There are a lot more consequences or options for a judge to consider if someone violates, their probation with juvenile court. So this is, even though this may be last resort from, Diane and Renee's standpoint, from the DA standpoint, who they're not in the room, it's not a criminal matter, so they're not representing any party, but they talk to the folks. Some folks call the DA's office. I know some folks are calling police stations and high schools. This may be a decent option for the parents to say, listen, yeah, I could charge him. He punched holes in the wall, it's criminal mischief, or he took a swing at you. I could charge him with simple assault. I could refer it up to juvenile probation office. A petition could be filed. Maybe this is the better way to go. And we explain that to the kids. When we see some of these petitions and we see that there's some conduct in here that probably could give rise to criminal charges in juvenile court, we say, listen, we advise them as to what their options are and what may make sense for them. And so I think some of the police officers, when these have been scheduled, a police officer or two have come up to the third floor where juvenile court is held, and so where these are held, to either talk to, in support of the parents, or to talk to Rob or I, and that's the route they have advised, and it's kind of worked out. And that's another reason why we advise the children to say, listen, A, you need to go through this assessment, and B, you may want to consider agreeing, even though it's still being court ordered, so it would still be considered involuntary commitment. You may want to agree that it can be entered as an order of court, because this can go in a couple different directions, and so the police officers, law enforcement may want to be mindful of that. And I think so far, all the ones I've had, Rob and I each had 6. I'll bet you 4 of mine have come from right on the heels of police contact, and I think the police officers have advised the parents pretty appropriately in that vein.
And sometimes there have been pending charges, and the DA has been able to.
Yeah, sometimes a lot of things are going on. There's an involuntary commitment petition filed. There's a referral to juvenile probation, and so they're considering a petition. And also, children and youth have been involved. They've been up on the floor. They're on that floor anyway. And Dan Keene, who is one of the solicitors for children and youth, has kind of been brought in to kind of monitor the situation, because these things can turn into dependency cases also, where the parents have said, I can't, the child is incorrigible, or I can't meet their needs. I need some help. I need some services from children and youth. Yes, sir.
Yeah, I was just going to mention, I think the greatest value of this Act 53, just as you're mentioning that this could be leveraged in place of criminal charges, I think this gives us so much leverage as parents and as everybody in the room to even get the kids. I think the vast majority, 99% of them would say, if they knew, hey, this could go to Act 53 to be forced, they would voluntarily then get treatment. I think that's what it really gives us, is a lot of leverage with the kids to convince them to get help before it has to go to this step.
That's absolutely true, and I don't want to get into this specific case because I don't want to go too far afield, but I've had that exact situation occur with, I have had 2 of them go to hearings, evidentiary hearings, where the child has not agreed, and then ultimately at the conclusion of the hearing, some of those conversations, we revisit those conversations and say, here are your choices, here's what's going on. And I think some of the kids see the light of day, and I have a child, one of my clients right now is in residential treatment out in the Pittsburgh area. And I've been in contact with him because we've already had 1 review hearing, and there's another one scheduled for the end of the month. So I've been in touch with his primary therapist, I've been in touch with him, and now his parents. And even, they're not represented, so I can speak to them. And as Rob said, it can be difficult. I have to try to be careful not to advise them when I represent their child. But it's actually worked out, I think, the way it was supposed to, is the way I want to say it.
I did want to also mention that beyond the Act 53 mandate. We want to make sure that we are available to families for general support throughout their frustration with the process, which can be pretty laborious to get through. I happened to be at court one morning, and Karen was there seeing 2 or 3 cases, and Dan was there, and I ran into Renee as well, who was there too. I was really struck by Renee happened to be there and either happened to be carrying doses of Narcan or did it deliberately. We carry them everywhere now. And so Renee met with the parents while the child was being assessed and showed the parent the video on Narcan that we show to anybody, as well as provided that parent a box of Narcan which contains two doses. So this is my way of saying to you all, please help families to know that beyond whatever help their child can get, and we certainly hope they're developing some long-term recovery, we want to support the parents as well. And so arming them with whatever tools they need, aside from treatment and mutual aid groups or self-help groups, we want to make sure that parents have access to Narcan. Even though many adolescents present using simply marijuana, we know it's not simply or just marijuana. We know there are many other substances, and it's a really slippery and quick slope to medications and to opiates and ultimately to heroin. We do have a flyer that explains to folks in the community, and we'd love you to encourage family members to just walk into our office. We're in Warminster on Lewis Drive. You probably know this already, but anybody who's a resident of Bucks County can simply walk into our office Mondays and Tuesdays from 10 a.m. to 1 p.m. and meet with one of our staff. It takes maybe 20 minutes. We talk a little bit about addiction, very little about their situation. We ask very few questions. We show a Narcan video that's through Adapt Pharma, our provider. And then we provide a box of Narcan to community members. And we've had over 100 community members since December come into our office. We ask individuals to fill out a form if they ever use it and to provide it to us to tell us how it worked, if it worked, how many doses had to be used. And we know of 4 individuals, at least Bucks County residents, whose lives were saved by the Narcan that was provided just from our office. So we want to make sure that anybody who would have an AED, anybody who would have an EpiPen, any other life-saving device would have doses of Narcan. So please encourage individuals to come in. I know for those of you who are Bucks County employees that the county has already made available through our office training to your staff and doses to your staff, so you should already have them. If you don't, please contact our agency. I know you were to develop policies, and you probably are in the process of doing that. If you haven't already, but we've made it available per the CEO of Bucks County to make sure that we provide doses to any Bucks County department who is looking for them. So please encourage folks to come into our office. And the not well-kept secret is that if they don't come in on Mondays and Tuesdays from 10 to 1, you can come in anytime. And as long as somebody's in our office, we'll make sure that we see you. It's great to call in advance if you can, but anybody can just stop in. Thank you.
One last housekeeping matter. Mr. Whitley has asked me to let everyone know that the Bar Association asked him to videotape this so that he may, or they may, disseminate it either through YouTube or other social media for anyone who wants to get any information or review it with parents or some attorneys. That I know Chelsea Jackman's going to run back and tell every DA to watch Rob and I, and also to remind you, you can call any of the 4 of us, Karen McKenna, Aldi, Gordon Hornig with Penn Foundation with any questions. But really appreciate everyone coming here and look forward to seeing you all again. Thanks.